Thank you, Jennifer, very much. Good morning, everyone. It's great to be here. I'm just going to, get myself a glass of water. Again, thank you all for being here this morning. Thank you for the very kind and warm introduction. It's my pleasure to be here as the newly minted CEO of the Law Society. I think I've been on the job now for about 100 days, and it's my pleasure to meet all of you as a group and come to the plenary for the first time. And this morning I'm going to spend a little bit of time telling you about myself, a little bit about my approach to professional regulation, my vision for the Law Society, including how I hope that I can help licensees better understand the Law Society and have greater satisfaction with the Law Society. In my view, the Law Society needs to be there to help licensees be more successful and elevate the profession. And so that's what I want to talk a little bit about with you this morning. So there's an overview of things I'm going to talk about. I'm not going to go through that whole list, but I'm going to jump right in. I began my career as a lawyer, first practicing in Toronto, and then I practiced for about 3 years in Stratford, Ontario, which is close to my hometown of St. Mary's. If some people might know that, home of the Canadian Baseball Hall of Fame. If you don't know that, a little anecdote about St. Mary's. And practicing, or having practiced both in urban and smaller community settings, gave me a very early appreciation for the diversity of legal practice across Ontario, and for the very different realities that lawyers and paralegals face depending on where and how they serve their clients. Over the course of my career, I've had the opportunity to lead organizations in government, in the broader public sector, in the private sector, and that included time as the CEO of the Workplace Safety and Insurance Board. And across those different roles, one principle has consistently guided my work, and that is that regulatory authority exists to protect and advance the public interest. And that principle is what drew me out of private practice out of the private sector back to the Law Society, to be re-anchored in that principle in my professional career. So for me, this role as the new CEO of the Law Society reflects a career that's grounded in law, public service, and a commitment to serving an organization with a critical public service and public protection mandate. Now, since stepping into the role, I've focused on understanding the LSO's key operational and policy challenges, listening closely to licensees and stakeholders. I've had the pleasure to meet with many stakeholders like members or representatives from FOLA, both yesterday but also when you were here for your lobby day, meeting with representatives from the OBA, from Ministry of the Attorney General, many others. And all of those conversations have been enormously valuable in helping me build a clearer picture of where the Law Society is today and how we can move forward together. I wholeheartedly believe that the work of the Law Society matters, and it matters enormously. Our mandate, regulating the legal professions in the public interest, is foundational to public confidence in the justice system, the rule of law, the functioning of our democracy, and of our economy. Much of the Law Society's work takes place quietly and behind the scenes. Now, you will know some decisions of convocation naturally draw more public attention or prompt strong engagement among licensees. But I can tell you those decisions represent only a portion of the day-to-day work that the Law Society carries out in the public interest and in the support of the professions. The work of the Law Society protects the public, strengthens the professions, and supports access to justice. And like many professional regulators, the Law Society carries a unique responsibility. We are both the regulator and the steward of professional self-governance. And the privilege of self-regulation ultimately depends on public trust. And that's trust that must be earned and demonstrated and renewed. And in today's environment, we know that trust cannot be assumed. It must be built through and how we do our work every day. And so that is why I believe that the Law Society should aspire to something very clear: to be the model professional regulator. Now, for me, being a model regulator reflects 4 simple ideas. First, and I'd say foremost, we must have a service orientation. The Law Society exists to protect the public, but part of protecting the public is helping lawyers and paralegals succeed in meeting their professional obligations and being successful in their practice. That's part of our job as a regulator, is helping you succeed. Second, a model regulator, we must support compliance as much as enforcement. Strong regulation is not only about discipline, it is also about providing timely guidance, practical tools, clear expectations, so that most issues are prevented before they arise, and enforcement can then focus where it's truly needed. Third, self-scrutiny. A model regulator must be willing to examine its own processes and actions, measure how well we're doing and working, and acknowledge when improvement is needed or mistakes have been made. And fourth, looking to the future. Technology, demographic change, access to justice pressures, and evolving business models are all shaping our legal landscape. You know that better than anyone. So our responsibility as a regulator is to ensure that the regulatory framework evolves with those realities. These principles already guide much of the work that's underway across the Law Society. They shape how we approach our responsibilities and the practical challenges ahead. Now, one of the areas where these principles come through very clearly, in my view, is how the Law Society thinks and how we need to think about legal services and the health of Ontario communities. Every day, you as practitioners face a very concrete, real reality. And that is that lawyers and paralegals, you were talking about it this morning, even in the updates that I had the opportunity to listen to. Lawyers and paralegals are critical in supporting economic activity, market stability, social confidence. Communities with strong legal support systems are better positioned to grow, adapt, and thrive. So that's why the access to justice challenges in smaller and underserviced communities are so important to the Law Society. As many of you know, in February of 2026, the Law Society Board of Governors, or Board of Directors, convocation, approved a set of Access to Justice Committee strategies focused on recruitment, mentorship, succession planning, and outreach in high-need areas. And this work was initiated in response to FOLA's motion at the 2023 AGM, which sought to encourage licensing candidates, new lawyers, and paralegals to establish practices in communities where legal services are scarce. And now, work is underway on collaboration with key stakeholders, including local associations, paralegal organizations, and academic institutions. So I want to commend FOLA this morning on bringing this matter forward and for your continued leadership on this issue. And I look forward to working with you as we move this forward. We can expect that the Access to Justice Committee will bring forward its first biannual progress report in September of 2026. In addition to that work, I want to take the opportunity this morning to share a few governance and regulatory updates with you while I'm here. First, Convocation approved just in its last meeting a governance review task force recommendation that support more effective, responsive, and modern governance of the legal profession in the public interest. These changes include reducing the size of Convocation, or the board of directors, and as many of you may not even know, the current size is 53 members of the board. And the recommendation is to reduce that number to 37. And in addition, or as part of that, creating 3 new skills or attributes-based positions to be appointed by the Law Society. Now, I do want to emphasize that the implementation of those recommendations require amendments to the Law Society Act, which require approval by the government. So we're working now with the Ministry of the Attorney General, with the Attorney General's office, to work with government to help advance those amendments to go forward. I want to just speak a little bit about the 3 appointments, the skills-based appointments. They're designed to help ensure that the governance board has a range of experiences and perspectives, including an Indigenous appointee and a Francophone licensee appointee. As I said earlier, self-regulation is a privilege, and this is an important step for the Law Society, recognizing its ongoing obligation to make sure it is governing itself more effectively and efficiently. I also just want to speak a little bit about the Convocation's recent approval of approval to implement an Indigenous cultural training course called Shared Pathways. The course is focused on enhancing an overall knowledge and competence of licensees regarding Indigenous legal issues impacting all areas of practice. Our goal is to ensure that licensees have an essential baseline level of knowledge and competence. The course will be mandatory for licensees who are subject to CPD requirements, and will be a component of the existing mandatory CPD. The course will be a one-time obligation, delivered online and at no cost. The completion of the course will fully satisfy most licensees' annual CPD requirements in the year that the course is completed. Now, we expect that the course is going to be ready for some people to start to take in mid to late summer of this year, but the mandatory or the CPD component requirement will take effect in January of 1st of 2027. Convocation has also approved recommendations to enhance personal and business information that licensees are required to report to the Law Society, and for the Law Society to disclose some of that information to the public where it is in the public interest to do so. Enhancing reporting under Bylaw 8 came into effect on March 31st of 2026, which requires all licensees to report to the Law Society on an expanded list of criminal and other charges and findings of guilt. We do expect further amendments to bylaws to come to Convocation soon to address the disclosure of charges and to facilitate the publication of all approved information on the lawyer and paralegal directory. Another set of changes that have moved forward, Trust Account Management and Enforcement Project called TAME. Convocation recently approved several significant measures under TAME. I'll highlight briefly just a couple of them. First, recent amendments to Bylaw 9 update, clarify, and streamline trust account transaction requirements. And also, secondly, the trust account authorization requirement was approved by Convocation in February. Under that requirement, licensees who operate a trust account must provide an irrevocable authorization directing their financial institution to provide trust account records to the Law Society upon request. This requirement will help ensure that the Law Society can respond effectively to increasingly sophisticated fraud, misappropriation, and other forms of trust account mismanagement. I want to speak very briefly about our licensing, candidate licensing process. As many of you may know, we undertook a consultation over the last year or so on reforming the bar admission course, or the bar exams. That consultation concluded earlier this year, and consultations like that are designed to help us understand, gather feedback, and ensure we continue to modernize how we regulate in the public interest. Now, over the last 20 years, the legal profession has evolved significantly. I don't need to tell you that, you know that. And so we also have to evolve how we administer our licensing exam and what that licensing exam looks like. Our overall assessment approach has remained largely unchanged over the last 20 years. And at the same time, the Law Society data indicates, and that's data particularly from our professional regulation team, indicates that there are competency gaps in lawyers, particularly new lawyers. Errors from core practice skills gaps, professionalism failures, and practice management deficiencies consistently account for the highest number of Law Society complaints. Not substantive law, but these other pieces that we see in terms of the complaints coming, that's where the gaps are. So with these risks in mind, these gaps, we set out to modernize how entry-level assessment is done to better reflect the competencies that are needed and matter most in practice today, so that new lawyers coming into the practice are more ready than they currently seem to be. We're focused here on protecting the public, but also, as I said earlier, helping licensees be successful. How do we shape our licensing exam process to ensure or to bring better opportunities for success? We wanted to hear from the profession and the public on this proposed shift, and during the consultation period, we received a lot of important and significant feedback. Now, the good news is that the perspectives that we received back are significantly aligned. And so we're carefully considering all of the feedback that we received. Our focus is on getting this right. I said to some folks yesterday as we were talking about this again, I don't think there's another more important project we have in front of us right now than working on getting this right. And we need the time, and we're going to take the time to get it right. So because we want to make sure that any future model reliably assesses the new licensees have foundational competencies, knowledge, skills, and judgment to practice. This is about ensuring greater competency and doing an assessment and ensuring there is an assessment to determine that. And finally, in terms of projects, I want to just mention one last one, and that is the Access to Innovation project. So the Access to Innovation project that was started under our Futures Committee at the Law Society will be seeking feedback regarding whether we should continue with the project. The 5-year pilot mandate is coming to an end in November of 2026. And so we are going to be seeking feedback from you in terms of whether we should continue that project. The program has been aimed at serving as a practical regulatory tool that allows the Law Society to observe, understand, and respond to technology-enabled legal service models in a structured and supervised way. I mentioned, one of our attributes of a model regulator is looking to the future, and this project has been a part of how we do that in a structured and organized way. The program helps the Law Society gain early awareness of new technologies and how these technologies that currently operate outside of traditional licensing structures, how they can do that, but we are still able to ensure protection for the public. Input on the continuation of that program will be requested by August 28th of 2026. And I encourage you to read Convocation's reports on the Law Society website. And as I said, we very much appreciate feedback on the continuation of that pilot program. That program, as I just noted, is an example of how we want to approach the future. Deliberately, openly, and with input from those we regulate and serve. It also sits in a broader context that we need to acknowledge. The Law Society is emerging from a challenging period. I, as the new CEO, know that. I've come in, that's why I have come in. I'm a new CEO coming in at a time where we are going through change. And that's a period that affected confidence among licensees, stakeholders, and the public about the Law Society. And that's unfortunate because those are the people that the Law Society, all of you, and the public in particular, that we are charged with protecting and serving. And moments like that, I can tell you that coming in new, moments like that affect the organization. But they are also, and I have seen it, a test of the character of the organization. Throughout that time, staff across the Law Society remain focused, responding to concerns, and upholding our public interest mandate. We have learned lessons, and we have acknowledged that we can do better. And as the CEO, I can tell you, as the new CEO, we are not dwelling on the past. But we are looking forward to the future, and we are embracing the future, and we are excited about the future. I couldn't be more excited to be in this role and to be leading the Law Society and working with all of you as we move into the future. And what does that mean? Well, that means ensuring that our operations, our regulatory, adjudicative, and public-facing functions operate efficiently, fairly, and consistently. It also means developing meaningful performance measures so we can clearly demonstrate how we're serving the public. And it means ensuring that our governance, risk management, and communications are strong and transparent. As I said, I'm excited for the future, and I'm honored to be the CEO of the Law Society of Ontario. And I very much look forward to working with all of you, the leadership of FOLA, as we continue to strengthen the Law Society and the profession to serve the public interest. Thank you very much.